Dustin, are you ready to start?
Yeah, go ahead.
All right. Go ahead, Mr. Chairman.
Okay, good morning, fellow commission members. Today's date is October the 15th, 2020, and it's approximately 9:02 a.m., and I'm Walt Valentine, Commission Chair. I'll now call to order the meeting of the Tennessee Private Investigation and Polygraph Commission. Executive Director Cody Vest, please call the roll.
All right. Thank you, Mr. Chairman. But before I call the roll, I'd like to turn this over to our staff attorney, Ashley Thomas.
Good morning. Can you all hear me?
Yes, we can.
Alrighty, I just need to read the statement of necessity into the record. This is the regularly scheduled meeting of the Tennessee Private Investigation and Polygraph Commission, which is taking place via WebEx in accordance with Executive Order 60, which is in response to the novel coronavirus pandemic. Notice of this meeting was posted to the Commission website on October 12th, 2020. If there is not a physical quorum present, a statement of necessity will be read into the record. Pursuant to Tennessee Code Annotated 8-44-108B2, which states, if a physical quorum is not present at the location of a meeting of a governing body, then in order for a quorum of members to the governing body must make a determination that a necessity exists. Must include a recitation of the facts and circumstances on which it was based. Further, Tennessee Code Annotated 8-44-108A3 defines necessity as matters to be considered by the governing body at that meeting require timely action by the body, that physical presence by a quorum of the members is not practical within the period of time requiring action, and that participation by a quorum of members by electronic or other means of communication is necessary. Again, this is the regularly scheduled meeting of the Tennessee Private Investigation and Polygraph Commission. The purpose of this meeting, with members attending via video conference, is to discuss the agenda as posted to the Commission website, and voting will be conducted by roll call. Thank you.
All right. Thank you, Attorney Thomas. But would you, you've kind of faded in and out on us. So would you please send me a copy of that so I make sure I include that in the minutes?
Absolutely.
All right. Thank you. Now, if you're ready, Mr. Chairman, I'll do a roll call.
I am ready.
All right. Walt Valentine.
Yes, present.
David Brown.
Present.
Stuart Bain.
Present and accounted for.
Robin Johnston.
Charlie Bradley.
Okay, somebody needs to
Run the meeting.
put themselves on mute there. I'm having difficulty. Okay, Alan Russo. Kendall Barham.
Present.
Charles Bradley.
He's coming on right now.
Oh, he's having difficulty.
Yes, he'll be there in just a second.
Okay, so I got 1, 2, 3, 4. Let the record show I don't have Alan Russo, and don't see. Well, there's Doug Shanks. I didn't hear you, Mr. Shanks.
I didn't hear you either.
Oh, I'm sorry.
So I'm here.
So, and has Charlie come on yet? All right.
I don't see him.
All right. So what I said, you do have a quorum, but let the record show at the moment, Alan Russo is not present and Charles Bradley is not present. If Charlie comes on, we'll correct the minutes. So you do have a quorum, Mr. Chairman.
Very good. The next item is the agenda. I'd like to ask each commission member if they've received and had time to review a copy of the agenda. And if so, is there a motion to adopt this agenda?
Chairman Valentine, Commissioner Brown, I recommend we adopt the agenda.
And
Commissioner Shank seconds.
Okay. All in favor? Say aye. Well, I guess we'll have to do a roll call, won't we?
Yes, sir. We'll be doing a roll call, but let me make sure I heard that. The motion was made by Commissioner Brown, seconded by Mr. Shanks to adopt the agenda. Is that correct?
Seconded by Stuart Bain.
Stuart, oh, I thought I heard.
yeah, we both spoke over each other.
I think we both did.
Okay, okay.
Okay, so I'm gonna leave it, Mr. Commissioner Shanks. That's who I heard. All right. Walt Valentine,
Yes.
David Brown,
Aye.
Stuart Bain,
aye.
Robert Johnston,
Aye.
Doug Shanks. For some reason, we're
Aye.
not hearing. Okay, thank you. Kendall Barham.
Aye.
All right, the ayes have it, Mr. Chairman.
Very good. The next item is the minutes. Approval of the minutes for the last Education Committee and Commission meeting. Has each commission member received and had time to review a copy of these minutes? And if so, is there a motion to adopt these minutes?
I have read those minutes. I move we adopt them.
Do I hear a second?
Commissioner Brown seconds it.
Okay, it's been moved and seconded that we approve the minutes. Any discussion? Hearing none. All in favor, Cody Vest, if you would call the roll.
Was made by Commissioner second, Commissioner Brown.
Mr. Bain.
Yes.
Yes, Mr.
All right.
Brown. Bain and
Mr.
Brown.
I got it. All right. Walt Valentine,
Aye.
David Brown,
Aye.
Stuart Bain,
Aye.
Robin Johnston,
Aye.
Doug Shanks,
Aye.
Kendall Barham.
Aye.
Ayes have it, Mr. Chairman.
Okey doke. Next would be the legal report.
All right, good morning. I hope everyone's got a chance to review the legal report. The first two cases on here are related as they are the same respondent, but two separate complaints. And then numbers 3 and 4 was the same complainant, but the respondent was, one of them was the PI and the other was the company. So just thought I'd give that background. And I'll reference that when we get to 3 and 4 as well, just for clarification. But the first case on here, complaint number 20200454141. The summary is that the respondent worked as an intern to obtain her PI license at a licensed private investigation company in 2011. While she was with this company, the company was investigating the death of the complainant's wife. It is unclear the exact amount of work the respondent actually did with this company on the case, but that company also made a complaint against the respondent. See below number 2 on this report, case number 20200039531. After receiving her license, the respondent started her own company, and she also started a podcast in or about April 2020, in which she began to share details of the complainant's case. The complainant stated respondent also has a Facebook page under a different name that she's used to harass him and his family. The Facebook page for respondent's company has a name that is not licensed with the commission. It does not appear that the respondent works for a licensed company at this time. The respondent did not fully cooperate with our investigation on this case. Respondent admitted to being one of several administrators who used the Facebook page that was allegedly harassing the complainant. However, she, the respondent, would not provide a response to any of the questions asked of her by our investigator. In the respondent's podcast, she discusses the complainant's method.
Okay, let's hold just a moment here. Looks like we're having some technical difficulty with Jesse. He might have lost the website there. I mean, the connection. If he's not able to connect, Ashley, are you still out there? Yes, I see you're still connected.
I am. I'm gonna pull up the legal report now if he can't connect in a couple.
Okay,
minute or
thank
two,
you.
and I'll keep reading.
Thank you. It's just that kind of day, commission members.
It's
that time of year.
Oh, yes. I think we're all kind of used to this. We'll just adapt the best way we can. Move on.
I'll just be looking over Cody's shoulder.
Okay.
That's good, Stuart. That's good.
Okay, Cody, if you want, I have the legal report pulled up. I'll read Jesse's.
Here he is. Looks like he's coming back on. Jesse, is that you? You back on?
It is. I am. I just noticed that everyone disappeared from my screen, so I set my phone to a mobile hotspot, and I think I'm on the hotspot now. So let's see if technology will bear with us.
All right. Thank you.
I apologize. I had a formal hearing yesterday via WebEx and had no issues, so I'm not sure what happened this morning. I think it looks like I got dropped around. Well, I'd stated that the complainant was never a client of the respondent. Does that sound about right? Does anyone?
Yes,
Okay.
that's the second paragraph on the second page. Yes.
She was
Perfect.
not
I'll just,
cooperative.
okay, I'll pick back up there.
Or the
The
third
complainant.
paragraph.
Oh, third paragraph. Okay, I'll pick up there then. The respondent is subject to discipline for failure to cooperate with our investigation, which is Tennessee Rules and Regulations 1175.04.02. The respondent also appears to be subject to discipline for running an investigation company without licensure for that company, which would be Tennessee Code Annotated 6226-204, and potentially for making public statements that are not completely objective and truthful, which would be Tennessee Rules and Regulations 1175-04-.04, and revealing information for a client obtained in an investigation to another individual, Tennessee Code Annotated 6226-22-1. The recommendation of counsel would be to authorize formal charges with the offer to settle this matter with voluntary license revocation.
Okay, Jesse, I'm sorry. Can you go back and read the paragraph that starts the complainant was never a client? I
I will.
believe that's where we left off.
Actually, where you left off
Where
was
was it?
she would not provide a response to any of the questions. Halfway through the previous paragraph.
I'll read back.
Okay.
I'll just start at the beginning of that paragraph. The respondent did not fully cooperate with our investigator on this case. The respondent admitted to being one of several administrators who used the Facebook page that was allegedly harassing the complainant. However, she would not provide a response to any of the questions asked to her by our investigator. In the respondent's podcast, she discusses the complainant's medical records, which it is unclear as to how she got them, and makes multiple statements that the complainant stated were false. Do you have the rest of it? Or
Yes, you need to read the next paragraph.
okay, well, the complainant wasn't a client of the respondent nor of the company she previously worked for. However, the respondent now appears to be working for a suspect who was allegedly involved in the murder of the complainant's wife, as the respondent's ex-husband has stated that the respondent is receiving payments from this other suspect, and the respondent's statements on her podcast seem to advocate for the innocence of the other suspect while alleging the complainant was the actual murderer of his deceased wife. The respondent is subject to discipline for her failure to cooperate with our investigation. The respondent also appears to be subject to discipline for running an investigation company without licensure for that company, for making public statements that are not completely objective and truthful, and revealing information for a client obtained in an investigation for another client. Therefore, the recommendation would be to authorize formal charges and offer to settle this matter with voluntary license revocation.
Okay, any questions for Jesse? I have one, Jesse. Has this been shared with law enforcement?
I believe the complainant has talked to law enforcement. I know when we jumped on to number 2, the complainant, which was the company that this respondent used to work for, has talked to law enforcement and is also contemplating a defamation lawsuit as well.
Okay, very good. Do we need a motion on?
Yes.
Okay. You've heard that the first complaint on the legal report. Do I hear a motion?
Given the fact that the information just surfaced that law enforcement was in some measure involved, I move we accept this recommendation.
Do I hear a second?
Commissioner seconds it.
Okay, it's been moved and seconded. Any discussion? Hearing none. Executive Director Cody Vest, would you call the roll?
Walt Valentine,
Aye.
David Brown,
Aye.
Stuart Bain,
Aye.
Robert Johnston,
I,
Doug Shanks,
Aye.
Kendall Barham.
Aye.
The motion carries, Mr. Chairman, to accept the recommendation of council.
Okay. Mr. Gentry, do you have a second?
I do. This number 2 on this legal report, like I said earlier, it's the same respondents, the same individual. This complaint was made, though, by the company that initially sponsored her for her PI license. This is complaint number 20200395531. This complaint covers the same private investigator and facts presented above. However, this complainant was the company that the respondent interned for. This complainant alleged that respondent used details in the investigation of the murdered wife case and disclosed them on the respondent's podcast without permission. The respondent initially came to the complainant as a potential witness to the above discussed homicide case, and after working together and providing testimony regarding the case, the complainant sponsored the respondent for her PI licensure and allowed her to work for her as an apprentice. Additionally, this complainant stated while the respondent worked for her, the complainant received notice that the respondent had accessed client files in the business Dropbox that the respondent should not have had accessed. The complainant told her that if she disclosed this information to any other parties, he would report her to the commission. The complainant was contacted by other individuals shortly after this incident, stating that the complainant had contacted them to, quote, dig up dirt, end quote, on the complainant. Further, the complainant became aware that the respondent was allegedly working as an investigator for one of the homicide case's suspects after leaving employment with the complainant. The complainant also stated that the respondent had previously offered testimony against these suspects and was now on her podcast recanting statements that she made against these suspects. The respondent has also apparently contacted several suspects whom the complainant investigated and has told them to, quote, fight back, end quote, against the complainant. Like the above complaint, the respondent did not cooperate into the investigation of this complaint and appears to be working for and running an unlicensed private investigation company. The respondent is subject to the same grounds for discipline as noted above, but from the knowledge and statements of this complainant, there appear to be more facts and firsthand knowledge regarding the information accessed by and then disclosed by the respondent. This complainant has also stated the respondent has multiple DUIs and arrests, but she alleged that the respondent has provided different social security numbers and names to avoid these cases being added together. There was one DUI that we received information on. However, the complainant was not able to provide the other copies that she stated were uncovered. And I will add that since drafting this summary, I believe we may have received some other information, but we haven't been able to fully investigate that. But that is still something that is being investigated. So the recommendation at this point is to authorize formal charges and the offer to settle this matter with voluntary license revocation, as with the first complaint as well.
Okay. Do I hear a motion on this?
Commissioner Brown moves that we accept council.
Do I hear a second?
Commissioner Shanks seconds it.
Okay. Moved by Brown, seconded by Shanks. Any discussion?
I do. I have a question. I might got lost here. So is this the company that hired the woman? Or is this the woman who?
Oh,
okay. I don't
I'm sorry.
understand that.
I'm sorry, not the second company. That's right. That's something that should be clarified. This was the initial company she worked for while she was apprenticing. After she left there, Cody Vest and I had discussed she was working for another company while also running this unlicensed company and podcast. And then shortly thereafter, this other company that she was working for, Ms. Vest, that was reported on her license that she was working for, she's no longer working for. But that's not this company. This is the company she apprenticed for initially and sponsored her.
So we're holding that company responsible for her behavior.
Well, she left employment, or left after apprenticing with this company, and then started doing this activity. So I don't think that they would be responsible for her activity.
Okay. I'm just clarify that. Shauna, are you on the line? Seems like Charlie's trying to call in. All right.
Yes, I'm on the line. I'm watching.
Okay. How about try to call Charlie? He's trying to get on the line.
Okay.
Thank you. All right. Are you ready for me to take a roll call vote, Mr. Chairman?
Well, one other question, Mr. Gentry.
Okay.
It seems like instead of a voluntary, it seems like we ought to just revoke their license.
So if we do that, we would have to have a formal hearing. This is her offer to settle it. If we wanted to revoke her license, if she doesn't settle with the voluntary revocation, we would then set it for a hearing, likely in January, I believe, next commission meeting. So,
all right. Well, okay, as long as we get her out of the business, that's the goal.
And she, her license, I'm sorry, never mind.
Okay. Director Beth, we're ready for a roll call.
Excuse me. Walt Valentine.
Aye.
David Brown.
Aye.
Stuart Bain.
Aye.
Robin Johnston.
Aye.
Doug Shanks. I'm sorry, Doug, I didn't hear you.
Aye. I didn't hear my name, sorry.
Kendall Barham.
Aye.
All right. The ayes have it, Mr. Chairman, to agree with the council.
Okay. Mr. Gentry, is there any further?
There are two more, and as I said before, number 3 and 4, it's the same complainant, but we have two different complaints. One is against the private investigator as an individual, and the second is against his company. So I'll start with number 3. It's complaint number 20200600241. The complainant inquired about services from the respondent in April 2020 regarding the respondent being able to locate a person of interest, and sent her the information on fees and procedures. The parties discussed the next steps and the information the respondent would need to get started. The respondent stated that the complainant contacted him a few weeks later and was upset that there were not faster results. The respondent stated that he made the complainant's case a priority at that point. The complainant stated she had concerns with the investigation, and the respondent offered to cancel the investigation without any cost to the complainant. The complainant alleged that the respondent then used profanity and called her a racial slur. The respondent did not deny using the words. However, he stated he believed he was no longer on the phone with the complainant. Surprisingly, the parties reconciled and continued to work together over the next month. The respondent provided the address of the missing person to the complainant, and the complainant then hired the respondent to serve legal process on the person, as well as other individuals. After the respondent served the documents, the complainant was arrested for violating a court order. Apparently, there was a no contact order between the complainant and this missing person's children, and the complainant had included a personal letter to this child with the legal documents. The complainant stated that she was arrested due to a conspiracy between the respondent, the district attorney, and the judge, and that the respondent had unlawfully told her he could serve the paperwork without violating the order. The respondent stated the order was violated due to the complainant going to this person's home. According to the documents of the court, the order was violated due to the included letter by the complainant. The respondent's actions of serving legal service would not violate a no contact order. However, it is unclear whether he knew the additional letter was included in the envelope given to him by the complainant. Overall, it does not appear that there is any evidence of misconduct or grounds to discipline the respondent regarding the issue with the complainant's arrest in violation of the no contact order. The commission could decide to discipline the respondent for using a racial slur against the complainant, as applicants for licensure are to be of good moral character and are to remain of good moral character. However, if the commission decided this was warranted discipline, a letter of warning would be the most appropriate form of discipline. It's concerning that the respondent would use this language. However, as the complainant reconciled after the language was used and continued working together, it did not appear to be so egregious in the mind of the complainant. So the recommendation would be to close.
Okay. Do I hear a motion?
Commissioner Shanks makes a motion to accept the recommendation.
Do I hear a second?
Second, Bain seconds.
Okay, Shanks approved, Bain seconded. Okay, any discussion? Hearing none, Director Best, would you call the roll?
Walt Valentine,
Aye.
David Brown,
Aye.
Stuart Bain,
Aye.
Robin Johnston, Doug Shanks, Commissioner Shanks.
Aye.
That was an I, in case you didn't hear. Kendall Barr.
Nay.
Kendall votes no. All right.
Charlie's online.
All right. Thank you. The motion carried, Mr. Chairman, to agree with council.
Okay. Mr. Gentry, do you have anything further?
Just one more case, number 4 in the legal report, complaint number 2020060781. This case is essentially the same in the legal report, case 2020060241, except the respondent named in this complaint is the company and the respondent in the other case was the individual investigator. There were no new facts alleged in this filed complaint. Whether the commission decides to close the other case or issue a letter of warning, this case should close. It does not appear that there was any violations by the actual company, and the issue regarding the racial slur used by the individual investigator may not be attributed to the company. So the recommendation for this one was to close.
Do I hear a motion?
Commissioner
Shanks
Johnson.
makes a motion to accept the recommendation.
I couldn't hear that. Who was that?
Doug
Shanks.
Shanks.
Oh, okay.
I hear a second.
Commissioner Johnston seconds.
Johnson seconds. Any discussion? Hearing none. Director Vest, would you call the roll?
Excuse me. Walt Valentine,
Aye.
David Brown,
Aye.
Stuart Bain,
Aye.
Robin Johnston,
Aye.
Doug Shanks,
Doug Shanks, aye.
Kendall Barr,
Aye.
and let the record show that Charlie Bradley has joined us. Charlie, so what is your vote?
Aye.
All right, thank you. All right, Mr. Chairman, the ayes have it to agree with council.
Okay. Anything further, Mr. Gentry?
There's nothing further on the legal report. I will add that we have one other case that the commission reviewed previously. We've been trying to settle it. The respondent had been in the hospital for a while, but in the event he doesn't settle it, or if either of the other previous cases need to have a hearing at the next commission meeting, that would likely be in January. So I'm not sure if everyone has participated in the training from the Administrative Office of Courts or the Administrative Procedures Division regarding the hearings via WebEx, but if they offer another one and you haven't taken it, I would recommend participating in that. So any questions you might have about hearings can be answered. I've heard that was beneficial to some of the other board members that participated in it and commission members.
Okay. Thank you very much, Mr. Gentry. Next item is appearances. Director Vest, do we have anyone wanting to appear?
No, sir, we don't have an appearance. I have one under the correspondence. The gentleman did want to discuss it. Mr. Culver, are you with us? I don't see his name on there. So we'll leave it down there with correspondence to discuss. And if it's okay with you, Mr. Chairman, we'll move on to my section there, administrative matters.
Yes.
But I did want to tag on the end of what Attorney Gentry said. There was only 3 commissioners that I remember now that actually took this this course with the judges. That's what I'm gonna call it. It was very beneficial. And Mr. Chairman, if you had not, I would recommend that you do listen to this if we have another one. So if you're interested, please send me an email and I'll try to get back with Judge Washington and see if we can have another meeting.
I believe
Has that one been?
I believe I attended that and found it beneficial. I would like to attend it again.
All right, y'all just send me an email and I'll see what I can between now and January. We got time.
Is that one on tape where we could review it?
I don't know the answer to that.
Okay. All right. Go ahead with any other administrative matters, Director Best.
And I think I said Judge Washington. Isn't that Judge Washburn? I may have mispronounced that. All right. Thank you. Let's just go straight on to the monthly meeting, and I changed it a little bit, and I just included the most recent one that we have here for September that shows we still do have some vacancies. Yes, again, I have sent the information up about the vacancies, and I understand that they are actively working on that. Of course, they said our next meeting was today. We have no legislation as of yet from the Hill that I'm aware of. We had our monthly meeting. We had our monthly finance meeting. Haven't had any media contact or marketing outreaches with the COVID or whatever. And on the month of September, there was not any complaints. So if you'd like, we just move right on to the budget. And I'm going to read that for you. It looks like in the month of January, you ended with 6,986. I'm sorry, let me restate this. I said January. July starts your new fiscal year. And as of July, it was 6,986. August was 1,874. So you ended up with $8,860 to the blank. We had, you heard the legal report, so that must have something to do with the increase in investigations and legal costs there. Anytime we have to do those. So if we stay on this trend, we could end up again in the blank. We won't have the what 1, 5, 10, 15, about 20,000, I believe it was, that we had for the exams. We won't have that this year because that's every 5 years. So I don't anticipate any large expense as of right now. So we're looking good for as a budget's concerned. Not too much and just enough.
I had a question about that, Director Best.
Right.
I noticed the largest expense we have for the 2 months, July and August, was the Edison expense. That was even more than the salaries. What benefits are we getting from Edison?
Edison is our computer system where we do. The core is also our system. When you say what benefits, this is the system that we use for payroll and other items whenever we use it, whenever we pay our commissioners for attending the board meetings. Whatever expenses we have, it comes out of Edison.
My goodness, that seems like an awful lot when it's even more than what we pay out in salaries. I presume that Edison came from the Hill rather than from within.
That is the system that the entire state is using. Yes, sir. It's a program.
Somebody got ripped off. Okay, that's enough.
Oh, okay.
By me.
We anyway, the PI Commission has done good in July and August. If you look at it a little bit, just give you an idea. Let's look at August. The license revenue was $15,070. Last year, come down to the bottom, you didn't take in that month, but 13,410. The month before, the year before that, you took in just a little bit, 15,408. So I think we're on track there. Looks like we're staying pretty even there. So that's what I'm anticipating anyway.
Okay. Very
All right.
well, thank you.
We do not have any legislative update, do we, Ashley? I don't believe there's any legislative update.
There's not. I don't have anything.
All right. We don't have any application reviews. What you have now is your correspondence, and Walt Culver, Culver, sent in an email, and I did send him the link because he wanted to appear today. He might have had technical difficulties. If you would go to the second page, you will see he asked 3 questions. And he wanted the board to give him an answer on these 3 questions. I will read the questions one at a time, and we'll have a discussion if that's all right with you, Mr. Chairman.
Yes, please do.
All right. Question number 1. Based on background above, hopefully you read all his background, what he wants to do. Is it the commission's opinion that a company domiciled in Tennessee but that locates and/or recovers lost property for clients both exclusively located out of state, neither in Tennessee, does not require Tennessee private investigators license under 6226? Well, you have to go back up and look, actually, see what he's saying he wants to do. He's recently located here to set up a supply chain consultancy company focusing on the location, disposition, and/or recovery of lost property using online and other sources. The clients and property both will be located out of state. The client will primarily be commercial business and their property.
Yeah.
My question is, if I give you a PI license and you're telling me that you're not going to be doing any work in Tennessee, if you have a PI license or company license, you can do any work in Tennessee. Your clients could be in Tennessee and do whatever you need to do. It's hard to say, I'm just going to be located in Tennessee. I'm not going to do any business. Then why did you need a PI license? Just to open up a business. But that's my opinion. So I would like to ask the commissioner members what their opinion is.
What do our attorneys think?
In reading his scenario, it appears that he's just going to be living here, but all of his business is taking place outside the state. So I'm not seeing where that business would touch Tennessee requiring a license.
Okay. Do we need a motion on this, Director Vest?
I think we can probably do it all at the end, if it's okay.
All right.
Okay, the reason I said what I said is the next one. Okay, number 2. Secondly, at some point, this one person business may wish to acquire a Tennessee private investigator's license and to add in-state clients, but not initially. If this company is structured as a sole practitioner, I assume it would be sufficient to only file for an individual PI license under 6226-206 and not for both an individual PI license plus a corporate PI license. Is this the commissioner's view also?
No, that's not what the rule says. You know, you've got to have, every PI license has to have a PI company.
Bain agrees. Also regarding question 1, I don't believe, I may be wrong, but I don't believe 6226-202 or 204 states specifically that a company can be located in Tennessee, domiciled in Tennessee, and do work out of state. It doesn't specifically address whether you're working out of state or working in state. So, and I concur on question 2 with Walt.
I have a question about number 1. And once again, I think he's operating a business. It sounds like he's going to operate a business in Tennessee. He's not definitive on that, but I get some concerns about that. I know he said he's living in Tennessee, but it also says that he may start a business in Tennessee.
Well, I think the point of anybody can open a business in Tennessee. I mean, you just go to the Secretary of State and open it up, or go to your county and city and get your business licenses. Anybody can open a business. So we already answered number 1, and number 2, I thought we had answered he would need to have a company license. That's what the statute says. At present, the statute says if you're going to be a PI, you either become a PI for yourself or you can't find a company to be affiliated with. Correct? That's what
This is
Yes.
Joe Steinbeck. Can I comment here as a practitioner in this area?
Well, sure.
I do unclaimed property as part of my PI business, and I've done out-of-state ones. In fact, I just had a client in Arizona. She had a very large unclaimed property. It took about 8 months to get it resolved and had it complete. As a person who's doing this, it would be my opinion. Of course, I'm just expressing the opinion as a PI practitioner who has both an individual license and a company license. It would seem to be unfair to a person like me who's doing all the things that are proper in terms of a PI training to investigate, because the reason that unclaimed property is originating in the state of Tennessee, because you start with state of Tennessee stuff like the companies. If it was a company that had funds here, or somebody was living here, in this case, I'm going to court records. I'm doing things that are Tennessee-like in order to get to the person who just happens to be living out of state. So I'm going through all of the same PI things that I'm trained to do. And so it'd be sort of unfair because I worked hard to get the PI license, and now we're just going to give away, well, you don't have to have a license if it's only outside, but they're doing the same things that I'm doing. So I just want to express that opinion if I'm making any sense.
Yes, sir. Thank you. And Mr. Stanback, he is a new PI, and I believe also a polygraph examiner, if I'm not mistaken. Thank you. Appreciate that.
Commissioner Brown, that was my line of thinking. If we've got people here in the state following, someone comes in outside, it's basically the same thing. Shouldn't it be licensed?
Cody, and my my analysis is under the guise of, it appeared that Mr. Culver was living in Tennessee.
Right.
The investigation would be conducting would have been done under the regulations of another state. For us to license him says that we are going to regulate his activity in another state, and that's overreaching. So that's why I voiced the opinion that I did.
All right.
So I have a question, Ms. Best. Maybe I was confused. I thought the unclaimed property was a Tennessee unclaimed property thing. Is that correct?
No, he said his company would be domiciled in Tennessee, but locates and or recovers lost property for clients both exclusively located out of state.
Oh, okay. So that might be a little different to Ms. Thomas's point. What my point was only Tennessee unclaimed property.
If it's only Tennessee unclaimed property, then they'd have to have a license. If it's out of state, then we don't have any regulations for out of state.
Yes, I would. Yes, Mr. Brown, I would agree to Ms. Thomas's point and Mr. Brown's point. I would agree to that as an outsider ejecting an opinion. If it was at another state's unclaimed property, then yes.
Oh, all right. Let me go back here to number 1. We said no. Doesn't need a company just to live in Tennessee. Number 2, yes, he must have a company. It's a requirement. It is a requirement. So we're ready to go to number 3.
Okay, can I go back on number 1? I
Yes.
think I agree you have to have a license, but I think we need to put language to him in answering that if you do work in Tennessee, you must be licensed so we don't go down a slippery slope. He's assuming, you follow what I'm trying to say?
Yes, whenever we corresponded, we would caution him if he does business in Tennessee, he would be required to be a licensed private investigator and have a company, affiliation, or start his own.
Okay.
We'll make sure of that. All right, number 3, to be licensed as a Tennessee private investigator, TCA 6226206 outlines the requirements which must be met. This includes specific experience or education under Section A6 with either 2,000 hours of investigative related experience or 1 year of education in a related area of study approved by a commission. Can the commission provide a list of courses that meet this education requirement in full? Private courses, community courses, or any other? If not, can the commission recommend a pathway or process to have this specific coursework approved that meets the education requirement? The answer I'm going to give this gentleman is you need to check our website because that information is on the website.
Agreed.
Agreed, yes.
It will help him if he has any questions.
I think that answers all 3 questions, Director Vest.
Yes, sir, it did, and we will correspond with him. I don't really, actually, I don't think we need to actually take a vote on that. He was just asking for correspondence, and I'm going to answer him. And I'm going to say at the commission meeting today, the October the 15th, the answers are, and I'll answer his questions. Is that correct? You think
That'll be fine. That will be fine. And then I would just, refer him to the video if he wants to see the discussion on his questions.
All right.
Okay.
All right. Thank you. Thank you so much, Sarah. We got that.
Good.
Now we can move down to the education. Let me explain that. The education committee now is meeting at 9 o'clock when we have our normal meeting. We were having the education meeting at 9, commission meeting at 9:30. But now, since the last meeting, we voted to incorporate all of it. I sent the continuing education out to commission members to review in advance. You did send me back your comments, and it appeared to me that the 3 courses, and we need to actually say what they are. The one that Charles Piper Professional Services, he wants to become a provider and an instructor. The information that I got back that everyone agreed, we did seem to think maybe some of these material was a little expensive, but if people want to purchase those books or whatever items, that is up to them. What we're looking at is approving him or the course. Do we have any comments from the education committee?
I will have one thing I'd like to ask. Do the requirements of a certified trainer come into play on this?
If he's going to be an instructor, yes. Is that what you're asking me?
That is exactly what I was asking you.
Okay.
I believe he would be, yes.
Yes. Well, that's why he provided his information, because he's going to instruct his own course. Apparently, he's written the books and going to do the whole thing. So he wants to be on our approved course list.
Well, and I would add, I've seen this person training before, and he delivers. He knows what he's talking about, and he delivers a good program. It was only on for an hour or so, a couple of times during our annual 6-hour seminars. Does he have to be a certified PI trainer in order to deliver the course?
I don't know the answer to that question without doing a little bit more research on that. Do you know? Ashley? I
I'm looking up the rule right now, Cody.
okay, thank you.
So the rule is 1175-02-.03. It says formal programs requiring attendance may only be considered if, and then subpart 2C says the program is conducted by a qualified instructor, discussion leader, or lecturer. I don't believe we've defined qualified instructor, but I would assume that is the commission's, I guess I would ask if the commission assumes that qualified instructor is a certified trainer.
We might be talking about two things, Stuart. I'm trying to do this by memory now. He wants to be an instructor to treat his for his course. He's not asking to be a PI instructor to instruct PIs, to become a PI, which we have the PI school and PIs that you do have to be an instructor to do that. I think we're talking about two different things.
Okay. Thank you, Ms. Vest.
So just for clarity of the record, you do not have to be a certified PI trainer to have a course approved. You can be qualified to teach that course.
Right.
Okay.
And that's what we're asking to do here. Do we have any other okay, the education committee, any other discussion on that?
Hearing none, we need to vote on that.
Yes, sir. Or we can just wait and do all three of them together, or we can do one at a time.
If I may,
Yes, sir.
I have an evaluation of this program. He is one place in his application, he had said 12 hours, and in another place he had said 10 hours. Frankly, folks, in my view, far more hours will be dedicated to this program, to doing this work, than 10. And so I would recommend the commission would approve it for 12 hours.
I agree.
Mr. Brown? On the education committee.
Aye.
Doug Shanks, are you, we're not voting, I'm just asking your opinion there.
I'm okay with making it 12 instead of 10.
Yeah.
All right. All right, let's go ahead and just vote for that then. So I'll make sure I have the right information here. What, Mr. Chairman, what we're voting for is Charles Piper's professional services, for Charles Piper to be the instructor and to approve his course for 12 hours for continuing education.
Yes.
All right, if you'd like, I'll go ahead and call the roll.
Please do.
Walt Valentine.
Aye.
David Brown.
Aye.
Stuart Bain.
Aye.
Robin Johnston.
Aye.
Doug Shanks.
Aye.
Kendall Barham.
May I ask for clarity on this question, please?
Sure.
Is this a vote of the Education Committee, of which I am not, or this is a recommendation of the committee to the full board that I'm now voting on?
Yes, it's to the full board to vote on this. Yes, sir.
Okay, thank you. Aye.
All right. Thank you, Mr. Barham. Charlie Bradley.
You're
Charlie,
muted.
you still, did we lose him again?
Oh, you just muted.
He's on mute.
All right. You need to come off of mute, Charlie. Because I need to hear you vote. All right. How do you vote, Charlie? Aye. Aye. I appreciate it. Thank you. This is a working process. We understand that. Okay. Then this course for Charles Piper's professional services for Charles Piper's and for the course has been approved for 12 hours for him to be a provider.
Yes.
All right, let's go to the next one is PI education. And I don't know really why I brought this to you. They are on the course list and they want 2 hours. But did the education committee have an opportunity to look at this? And well, you sent it back to me and you said yes. Was there any discussion with the education committee about it?
Yes, there is.
All right.
Just that the commission needs to recognize that the course syllabus indicates two different passing scores, one 70% on page 4 and one 75% on page 8. Can't be both, folks.
Whatever he suggests, whatever he approves is what it is.
I accept that.
Okay, you said on page 4 the score of 70% or better is what we're looking at. I think it's what we're looking at.
Yeah.
All right.
Yeah.
Any other discussion with the education committee? If not, we'll go to the board for approval.
Okay.
Wes? All right. Walt, now this is approval of PI education for 2 hours for ethics for investigators in theory and practice. Walt Valentine,
Approved. Yes. Aye.
David Brown,
Aye.
Stuart Bain,
Aye.
Robin Johnston,
Aye.
Doug
Shanks,
Shanks,
Aye.
Kendra Barham,
Aye.
Charlie Bradley. Okay, Charlie, you're going to have to come off of mute.
I'm aye.
All right, thank you. Appreciate that. The ayes have it, Mr. Chairman, so that has been approved, that course, PI education.
Okay. And the last,
All right. The last one we have is a Criminal Defense Investigative Training Council. This is for an individual. Her name is Natalie Matthews. She took this course and she wants to have it approved. It was approved. That the course actually was 40 hours, but of course we're only going to do 12. And it was already on August the 24th. She was in between board meetings to have it approved. Did the education committee take a look at it? Have any comments?
it was fine by me.
All right. Anybody else have any other comments? If not, I'll go ahead and ask for a full vote of approval by the commission. All right. Walt Valentine, David Brown,
Aye.
Stuart Bain,
Aye.
Robin Johnston,
Aye.
Doug Shanks,
Aye.
Kendra Barham,
Aye.
Charlie Bradley.
Aye.
All right. The ayes have it, Mr. Chairman, to approve the Criminal Defense Investigation Training Council for it says for 12 hours for Miss Natalie Matthews. Okay.
And that concludes the education report, I believe.
Yes, sir.
Do we have any unfinished business?
I'm not aware of any unfinished business.
We have any new business?
I would like to ask a question, if I may.
Okay.
We have, and I'm not sure whether it's unfinished or new, it's probably a little bit of both. We have, in the past, been paying attention to trends across our state. I might add our great state. And I'm curious if the executive director and her staff have a number, have an understanding of what the trends are in terms of number of licensed PIs and number of licensed polygraph examiners across our great state.
I can only give you the totals that we have that are licensed in the state. I can tell you how many individuals are licensed. That's why when we looked at the budget, the point I was trying to make is it looks like we're staying pretty even for as new investigators. You only have I think you've moved up to 62 polygraph examiners. But the PI trend is looking like it's staying the same the minute they're dropping off. But new ones are coming on, and these happen to, what we can tell for the trend is they are sole practitioner companies that are being added. If that answers your question, Commissioner Bain.
Yes, ma'am. Thank you.
I do look at these numbers constantly. I'm in correspondence with others constantly about these numbers. As a matter of fact, I had a meeting yesterday with the assistant commissioner about our department, and some of the numbers have gone down, but it wasn't in the PI program. So whenever our numbers start falling off a little bit, they always get with me to see if we can find out what's going on and see what we can do about it. Now, as far as if we don't have any other questions, we'll go to new business, which we must vote on the new dates. And there is a mistake out on the website that Shauna is getting corrected. The dates I believe that I sent to you were January the 14th, April the 22nd, July the 23rd, October the 15th of 2021. No one sent back to me any problems they had with those dates. And I actually looked at last year's dates and tried to keep them the same. Now, whether we're going to be doing this by WebEx, I do not know. This is just my opinion, and I would like to have the opinion of the commission, to bring 8 people in and we're almost ready to adjourn for an hour for you to come in overnight and the expenses. And that's what's really been holding things down with the PI board. But we have to go back there paying the expenses. It's going to affect the budget. I have asked the assistant commissioner if we can continue our WebEx meetings. We just don't know. Under the executive order, we're doing it from what I understand, to the end of the year, and then we'll go from there. May have to ask for something special. I don't know. So what do our commission members think? Do you want to go back to meeting coming in, and these dates, like I say, I matched them up best I could to last year, but I do not know of anything that's going to be happening in Tennessee with this COVID-19. I don't know if we're going to have any functions that you might not get a room. We'll just have to play it by month on that. But what do the commission members think?
Cody, Commissioner Brown.
Uh-huh.
First of all, our expenses have been cut. They read out.
Yes, sir. Your expenses have been cut a good bit. But now we don't always look at expenses. We're looking for what's better for the Tennesseans in this state, and having our meetings back in the office in this building. I should say they have made changes downstairs in the way that you'd be sitting. The audience, they have moved the chairs to, I don't know, 6 or 8 feet, whatever. We do have another, I think it's 1C, that is going to be our overflow room in case we have more visitors. We don't have that many, but a lot of the boards have an excessive amount of people that do show up. But I just want to be able to say to the assistant commissioner, number one, we would save money by having these virtual meetings.
Cody,
and number 2, I want to, yes, sir.
Cody, it seems like to me that we ought to see what the fourth quarter is with our budget and everything, and then at the beginning of the year, make a decision on whether we should meet in person or virtually.
Well, this is your last meeting of the year.
Bain would add that it would make great sense to me if we, at the very least, retained January 14 as a WebEx meeting.
I would go along with that.
For obvious reasons, namely, winter weather and flu season.
Get your flu shot.
I already got mine.
Got mine.
Yeah.
Me too. Okay. All right. So I think what we're hearing, unless some other commission members want to speak up, I'll whenever I have the meeting with the assistant commissioner about the board meetings, which I do, I will ask that we have the January meeting by WebEx so we can make decision then whether we're going to be meeting by virtual or whether we're going to be required by statute to go back and start having the meetings in the building. Is that what I heard?
That's what you heard.
Hey,
All
Cole.
right.
Commissioner Shanks,
Uh-huh.
if we have a hearing about something, I think we should be there. I'd like to see the person in person.
Yeah.
All right. That's why we are having that's why we had those meetings.
Yeah.
Some of the judges, from what I understand, and you correct me here, Ashley, if I'm incorrect, or Jesse, some of the judges want to do this virtually and some of them want to do them in person. Yeah, I think it's going to depend on the judge that draws our formal hearing. Is that what I understood?
Well,
Ashley, Jesse?
can we determine that rather than the judge?
No, sir.
But it seems to me like if we combine a hearing with our meeting, we could kill two birds with one stone.
I'm sorry. I'm sure you do have an opinion there. I apologize for that. But when it goes to if we have a case that's going to a formal hearing, it has to be set in advance. Jesse's going to have to get the judge. And like I said, each judge has their own opinion from what I understood from that meeting. Am I correct, Jesse?
That's correct. I have actually had some hearings that are being set in person right now. It seems to be going by, how the parties are agreeing. Based on how we're filing to put things on the docket for these judges, they do ask the location of the hearing. So if I specifically put in there, David Crockett Tower, 500 James Roberts Parkway, I think we could request at that point to have a judge who would be assigned to hold an in-person hearing. But I think that we could still potentially get a judge who, says, no, I want to be virtual. I have also had some judges compromise. I have a hearing coming up next month that the judge, me, and the respondent will be in person, but all witnesses will be by video conferencing because there's witnesses who still don't want to meet in person. So I think potentially we could say, if we want the commission to meet in person, and any witnesses we want to come in person, if the judge needs to be by video conference, if the judge is not comfortable, that could be potentially arranged. If a witness is not comfortable and wants to be by video conferencing, that could be arranged. But I agree, it does make it easier. If I have documents, if I can give you a physical copy of it, give a witness a physical copy of it, it makes it much easier than, and we'll look at my screen. Let's all look at this. Or if I'm sending emails out to everyone to refer to documents during the middle of a hearing. So I can I can make that request if that's what the commission would prefer. I can't guarantee that we'll have a judge who, wants to have everyone in person, but we can certainly make that request. And I think we are still at the mercy of the governor's office because our office is subject to those executive orders. So if, for some reason by January, this COVID-19 gets much worse and they shut down all government offices, we may be forced to be by WebEx or video conferencing. We may not have a choice. So I will make that recommendation though, but we may need to be flexible.
Okay.
Oh, okay. You said that so much more nicely than I did. Thank you so much there, Jesse.
Well, I'm just trying to do what these judges want to do. So
Right.
I'm, at their mercy every day, it seems like, when I'm filing hearings.
I do know from other directors that have had some virtual hearings, and then I do know they have had some in person. So like Jesse said, it's just going to depend. We just hope everything gets settled. We don't have to go to a formal hearing, because it's been a while since you've done a formal hearing. Walt, I believe I would get with you before then to go over some other things to make sure that we do a refresher course and everything, because a lot of it falls on you. I don't have anything to do with it. I just sit there, so it'd
No problem.
be you. But we'll leave it up to Jesse to go ahead and get those settled.
We'll cross that bridge when we
Hopefully.
get there.
There you go. All right, we didn't have any, but obviously this is where it's hard. Continuing education participant for him. Do we have anybody in the audience that wanted to make a comment? We do thank you, Mr. Standback, for your comments. Okay, I don't have any, sir.
Hearing none, we are finished with the Continuing Education Participation Forum. And the last item on the agenda is adjournment.
All right, let me call the roll. But this is for adjournment. Walt Valentine,
Aye.
David Brown. He was having audio problems. He was telling me. All right, Stuart Bain,
Aye.
Robin Johnston, Doug Shanks,
Aye.
Kendall Barham,
Aye.
Charlie Bradley.
Aye.
The ayes have it, Mr. Chairman, to adjourn at 10:12 on October the 15th, 2020.
We are adjourned.
Thank you. I appreciate it.
Okay. Thank
Goodbye,
you.
everyone. Bye.
Thank you, board members.
Everybody be safe.
Take care.